The ATF overreach has been stopped once again. Today we're talking the end of the pistol brace rule. Hello, my name is Rachel Moss, and I'm an attorney with the Attorneys for Freedom law firm. Today we're going to dive into how ATF has been stopped once again. On this channel over the past few months, we've been talking about ATF's overreach in the area of forced reset triggers and preventing FFLs from selling to 18 to 20-year-olds. And now we're going to dive in to the really exciting end of the pistol brace rule. So on July 17th, 2025, the plaintiffs and the government agreed to a stipulation of dismissal of the government's appeal from the district court's prior decision ending the pistol brace rule. This dismissal means that the district court's ruling regarding the pistol brace rule can now remain standing. With the appeal, it was pending. It was unsure. Maybe the pistol brace rule would come back into place. Maybe they'd say the pistol brace rule was okay. But with this ruling, we now know that the pistol brace rule from the ATF will remain vacated. In June 2024, the United States District Court for the Northern District of Texas, Fort Worth Division, granted the plaintiff's motion for summary judgment. The plaintiffs in this case, Mock versus Bondi, you might formerly know it as Mock versus Garland. But in this case, the plaintiffs had moved for summary judgment, which is basically saying we're not going to litigate the full case, but we think based on the information that we've presented to the court can enter a final ruling. So in their motion for summary judgment, the plaintiffs had requested a few things. The plaintiffs had requested that the ATF's pistol brace rule be vacated, and they also requested that a permanent injunction be entered against ATF. The court had granted it in part, and overall it was a victory. Basically, the court found that ATF's pistol brace rule should be vacated. They did not enter a permanent injunction against ATF, preventing them from bringing a rule like that in the future, but they said the rule as it currently stands needs to be vacated. The reason why the district court made this decision is they found that, in my opinion, unsurprisingly, ATF failed to follow the proper procedures in putting this rule into place. So overall, this is a great victory. This is what the district court found way over a year ago. Over the past few months, it's been really uncertain. Will this rule stay in place? Will it not? Will the government succeed in their appeal? And with this new administration, with Bondi taking over, there was some hope that something like this would happen and a dismissal would be entered. And here we have it. All these individuals across the country that have pistol braces can now rest a little more easy knowing that this dismissal is in place. But just as a refresher, what is the pistol brace rule from the ATF? Well, it's formerly known as the factoring criteria for firearms with attached stabilizing braces. So in effect, this rule reclassified large format handguns equipped with pistol stabilizing braces as short-barreled rifles under the National Firearm Act. So this was a big change for how things were classified. I'm going to read out to you what ATF's formal definition was. So from ATF, the definition of a rifle shall include a weapon that is equipped with an accessory, component, or other rearward attachment that provides surface area that allows a weapon to be fired from the shoulder, provided other factors as described in this preamble and in the amended regulations, indicating that the weapon is designed, made, and intended to be fired from the shoulder. This rule was put into place a few years ago, and as an effect to this rule, ATF was requiring individuals to now register weapons with pistol stabilizing braces under the NFA. So this was a big change for gun owners that were possessing these types of braces. After the district court granted summary judgment last year, the government appealed, hoping to reinstate the rule. They wanted this rule to stay in place. And this was back during the Biden administration when this appeal began. And briefings were even made in the case. The government put forth a brief. The plaintiffs entered a response brief to the government's brief, and it looked like it was on the track to go to oral argument that was requested. Eventually, once the Trump administration took over, there was a stay placed on the case, giving the Trump administration time to review the case. And eventually we reached this dismissal where we are now. So overall, the plaintiffs are very excited, and the gun community overall has been very excited with the change in this rule. The Firearm Policy Coalition was one of the plaintiffs in this case. Their president, Brandon Combs, stated, "The dismissal of this appeal should be the final nail in the coffin of this unconstitutional Biden ATF assault on gun owners." This is how many gun owners were feeling during this past administration. worried that their gun rights were at risk, worried that the ATF was slowly going to encroach on their freedoms. But overall, this is a huge victory that many people are celebrating. So what went into the district court's ruling? The district court found that ATF violated administrative procedure. So when these types of rules are put into place, there's a typical procedure that ATF has to follow. It all started with a proposed rule. And the proposed rule was about these types of stabilizing braces, but it looked a lot different than the final rule that was put into place in 2023. The proposed rule was based on a worksheet, and it showed a worksheet that gun owners could go through to determine if their item fell under the NFA and if they would want to register it based on that worksheet. Overall, the worksheet format allowed gun owners a little bit more clarity under the proposed rule than the final rule. It allowed gun owners to go through and have more standards to follow to determine if their item needed to be registered under the NFA. Under the final rule, it lacks clarity. There are some subjective standards to this rule where different people might come to different conclusions about whether their item needs to be registered. So the ATF put forward the proposed rule. Once you have a proposed rule, there's different processes depending on what type of rule it is, if it's an interpretive rule or a legislative rule. An interpretive rule is the type of rule, just what it sounds like. ATF is interpreting current law, basically looking at a statute and saying, okay, we're interpreting this, explaining what it means. ATF originally claimed this was an interpretive rule, that they were just interpreting what previous statutes meant when they defined terms like rifle. However, the court ultimately agreed with the plaintiffs and found this is more of a legislative rule. This is more making a new type of law in effect. And with a legislative rule, there's a certain process you have to follow. You have to follow a more expensive, time-consuming process that many agencies don't like to go through. It's called the notice and comment period. So I know now we're getting into the boring government procedure stuff, but it's pretty important. The whole point of the notice and comment period is to give the American people the chance to be heard. And people can provide feedback on the rule and let ATF know if they think this is a good idea or not. Or maybe it's a good idea, but there need to be changes made to the rule. Well, there was a lot of feedback to this rule. About 217,000 comments were left during the notice and comment period on this rule. And let's say over 200,000 of those comments were negative. Yes, there was tons of backlash to this rule. If you're a gun owner, you probably didn't like it either. There was so much backlash, but ATF looked at that backlash and said, we're going to keep the rule. We're just going to make it somewhat unrecognizable. So after the notice and comment period, they changed the rule, but they changed it to where it was basically nowhere like the proposed rule. And this is a problem because after the notice and comment period, to properly follow the procedure, the final rule needs to be a logical outgrowth of the proposed rule. So that's where ATF messed up. The court actually noted that normally the places agencies mess up is by just not having the notice and comment period to begin with. But here the ATF really messed up by not letting the rule be a logical outgrowth of that original rule. And that's because the rule didn't include that worksheet format. The district court found that the departure from the worksheet format was essentially enough to make the notice and comment period worthless. The ATF changed the rule so much that the American people really didn't have a chance to comment on what that final rule would actually look like. So that's why the district court found that ATF's rule could not stand. They did not follow proper administrative procedure with that logical outgrowth rule. Because of that, the district court found that there was enough to vacate the rule. But the district court went a little further and made some other findings. They found that the rule was also arbitrary and capricious. So the court didn't hold back. The court even said in their decision that ATF disregarded the fundamental principles of fair notice. So the ATF was truly called out in this case. They also found that the rule was impermissibly vague, going back to what we talked about earlier, that under the final rule, it didn't really give gun owners clarity on what items needed to be registered and what items fell outside of the rule. So overall, this is a clear showing that courts are trying to hold government agencies accountable, which is a good thing. They're saying you have to follow proper procedure, you have to give the American people clear notice, and your rules have to be clear. They cannot be vague where the American people are left uncertain whether or not they're committing a crime. And so this is a good decision. It is great that this appeal was dismissed. It is possible that the ATF could go through procedure in the future and institute another proposed rule, a proper notice and comment period, and create a rule that's a logical outgrowth. And we could have a similar rule like this in the future. Under the current administration, I don't really see that happening, but you never know. So overall, this is a big win for the Second Amendment community. It's allowing many freedoms to still be upheld here. And it's showing that we're not going to let government agencies get away with just anything. So I'd love to hear some of your feedback in the comments below. Are you excited about this new stipulation for dismissal? Were you a fan of the rule? Would you like to see a rule like this in the future? And what do you think about the government finally stopping ATF's overreach? Share all of your thoughts in the comments below. Thank you for tuning in to another video. If you'd like to learn a little bit more about our law firm, Attorneys for Freedom, you can check us out at attorneysforfreedom.com. Get to know the whole team. And we're the only law firm in the nation devoted exclusively to self-defense cases. And if you'd like to learn more about our self-defense protection program, you can check us out at attorneysonretainer.us. Attorneys on Retainer is a program where if you are in a self-defense situation and you are charged with a crime or reasonably expect to be charged with a crime and you are a member of our program, your legal fees will be entirely covered. And we recently added red flag law coverage. So again, you can check us out there at attorneysonretainer.us. And if you enjoyed this video, be sure to like, comment, share, and subscribe. We hope to see you next time. Peace.